So, John, just a few further questions. They won't follow a particular thematic or chronological sequence because they've been suggested from a range of different sources. So we'll dot around from topic to topic. The first is about the settlement of the HIV litigation. So we're talking here late 1990. Did the settlement of the HIV litigation have any effect, as far as you are aware, on the budgets of the territorial departments?
Let me think about that. I think the money was met out of the reserve, in which case, no. If it had been met out of the normal provisions of the health authority, of the health department, I think the answer is also no, because they would get a proportionate portion of the sum total of expenditure of those departments. So I think the answer to that is no.
Next question. I'd asked you about the, to some extent, about the obligations on ministers to be candid, open. Is there a responsibility and obligation on civil servants to be full and frank with the ministers in the advice that they give?
Yes.
Next question is about a public inquiry, not about your own decision-making, but about the decision to establish this inquiry. Was that something that was discussed with you in advance by the then Prime Minister,
No.
Theresa May? The next question is about the issue of no-fault compensation. Would you agree that insisting on victims proving fault, establishing legal liability, may get in the way of lessons being learnt?
Well, I think a new precedent has been established now of ex gratia payments. So I don't think you can get away from the danger of no-fault compensation, but there's now been a way to go round it and deal with cases where there is a special requirement because of an event that may not have been the direct fault of a government or government's servants in any capacity, but where compensation is merited. And I think the ex gratia payment proposal that was developed will meet that in future.
Now, a number of the documents we've looked at have used the term compensation, and I think I may well have used it in my questions to you. You've used the term in your answers. At the time you were taking decisions or involved in decision-making, late 80s through the 90s, did you understand there to be a difference between compensation as properly understood, compensating for the injury that someone has suffered and the loss they've suffered, and the provision of financial support or assistance, which is less than compensatory?
Well, there's two aspects of that. The first one is the Social Security payments, which plainly stand on their own, quite apart from the... I think compensation is the wrong word, actually. Ex gratia payments would be a more accurate way. It isn't compensation. Compensation in terms of... You cannot compensate. There is no way you can compensate for what happened to the victims of the blood tragedy. You cannot compensate. Wouldn't matter whatever you did for them or paid them. There is no compensation for the way their lives were wrecked. Let's be entirely clear about that. So I think compensation isn't the right term. An ex gratia payment is probably a more accurate way, but I'm not sure that there's a word that you couldn't take offence to if you wish to. But it certainly isn't compensation, which these days has also come to be used as a narrative for salary as well. Your compensation for doing your job is X pounds a year. So certainly we should get away from the use of the word compensation, because it doesn't and it can't.
Now, one of the themes of the decision-making that we've looked at was the government's desire to avoid setting a precedent. Is the answer or an answer to that concern about setting a precedent to investigate what happened and how it happened, and take steps to prevent that happening again, rather than just saying, well, we can't set a precedent, so we won't provide financial support?
Yes, it could be, but it would delay it. I mean, if we had decided that until we'd found out and had an inquiry like this to determine exactly what had happened, nobody would have received anything until now. So you actually, the payments were needed when they were needed. They were not needed in retrospect. And in the case of many of the early victims of this, they're no longer here, sadly, to receive a payment, compensation, call it what you will. So I think there is a need to act quickly. Certainly there are lessons to be learned, and no doubt will be learned as a result of this very extensive inquiry. And I suppose those lessons will spread into a whole series of different areas.
I next wanted to ask you about an answer you gave in your statement. I don't think we need to look it up, but you were asked in your statement what influence the forthcoming general election in 1992 had on policy making or decision making regarding the financial support or the provision of financial support or non-provision of financial support. What is your position in relation to that?
Well, it didn't. I mean, the things that were in train at the time of the election were the Maastricht Agreement, which had been wildly well received when first made and subsequently came under huge criticism, particularly from within the Conservative Party. And that produced a divided party and was a significant issue. Then there was the question of rising inflation, falling house prices, and the other economic problems that arose from events in the 80s, but carried a recession right into the early years of the 90s. And those were the mega issues of the campaign. And I can honestly say that the decision on a payment at that stage was not affected by the forthcoming general election and did not affect the election in any material way.
What percentage of the overall Treasury budget is the contingency reserve, or was the contingency reserve, in broad terms, when you were
Oh, golly,
there?
I can't tell you. I mean, it's. I think I said it was an art, not a science. So it isn't a fixed percentage of the overall budget. It's an assessment of what is judged. You don't exactly lick your finger and hold it in the air to decide, but it's certainly not a scientific examination. It's a guesstimate of what might be needed.
What's your understanding of what should happen to a departmental minister's private office papers when they leave post or move to a different post? Is your expectation they be archived?
I'm not as sure what is meant by private papers, because the papers belong to the government. So I'm not sure what is meant in that question by private papers. To the best of my knowledge, civil servants do not have private, well, I suppose they can write their own private diary, and that I assume would remain private. But they have no private papers within the department. The papers that they write and the papers that they receive are departmental papers, and they go into the official records.
So let me put it a different way, and it's a question I'm asking on behalf of someone, so this is my own paraphrasing of it. A minister's private office papers, what should happen to those?
Oh, they're in the archives. That's where the papers that the inquiry provided to me came from. They came from the archives that the government hold collectively of what has happened in individual departments over the years. I mean, to make the point clear, they are not papers that belong to the individual minister that can be destroyed, if that is what lies underneath the question.
It is, I think.
I think it is too. The papers belong to the government, and they are public papers. And one of the things that have changed, of course, from the 80s, in the 1980s, ministers and officials might scribble notes on the paper. Now, those notes at those time weren't going to be released for 50 years. So sometimes they were incredibly frank and sometimes rather rude. Take no notice of this, the man's an idiot, for example, you might find written on some of them. Now, of course, that's very useful to historians in the long term, because they actually get a practical picture of what is going on. I'm not sure that now public papers are released so much more speedily that that happens. Certainly in some governments after mine, notes such as that were written on little pieces of yellow paper that were stuck to the papers and then removed subsequently. And that's a loss to history.
I asked you a few minutes ago about the obligation of the civil servant to be frank and comprehensive in the advice provided to ministers. If briefings are given which subsequently come to the attention, whether of the same series of civil servants or later ones, were incomplete or potentially inaccurate or misleading, would you expect the civil servants who have appreciated that to bring that to the attention of ministers?
I think they would write a replacement minute. They'd probably be very discreet and say, circumstances have changed, there was a misunderstanding, the position is X. And I certainly wouldn't expect a mistaken brief to be re-echoed in subsequent briefs.
So you would expect in some form or another the mistake to be corrected?
Yes, I would. Just as mistakes made in Parliament should be corrected. If Parliament is misinformed by a minister, it should be corrected.
And then, last question on this topic. We've seen through some of the documents that we've looked at how a line to take is repeated from minister to minister, civil servant to civil servant, potentially from one administration to another. Does that risk policies, decisions, simply continuing almost through a process of inertia or apathy?
The answer to that question is yes, it can do. And I think you have to realise what the briefings are. The briefings are a background for ministers. They're not an instruction to ministers to stick to them. Now, often there is something that is so seared into the blood, as it were, that, I'm sorry, that was a bad analogy, it's so seared into the mind that it takes quite a lot to shift it out and change course. And I think you could perhaps argue that case over no-fault compensation. But briefs are that, they are briefs. And the briefs from civil servants are factual. I mean, you asked me earlier today, and I wasn't quite sure how to explain the point properly, how repeatedly there were minutes saying governments can take credit for this or take credit for that. And that sounds pretty awful. And it did sound pretty awful when you said it. But of course, it was and is the style of minutes. I mean, we are talking of a different age in terms of emoting between now and the 1980s and early 1990s and 2022. This is the age of let it all hang out. It certainly wasn't the age of let all your emotions hang out in the 80s and 90s, indeed quite the reverse. And I think that was reflected a bit in some of the apparently insensitive minutes, where I knew I had had discussions with ministers who were concerned about something, but the minutes that appeared did not seem to back that up. And I think that is probably why that happened.
And then just going back to this issue of there being an inertia potentially if a line to take or a policy is simply repeated, to what extent is it the role either of ministers or of perhaps more senior civil servants to challenge the status quo, to probe, to ask if there is a different perspective that should now be brought to bear?
It is with senior civil servants. But senior civil servants will probably go and see the minister rather than write a note to the minister and say, you have made a complete muck-up of this, we should be doing it differently. They will probably go and see them and talk to them and say, have you considered this? This is a problem. This isn't going to run. We've seen this before. It doesn't work. And actually, you saw an illustration of that this morning. William Chapman, in my private office at number 10, was not a permanent secretary. But you don't get to be one of the handful of secretaries in the Prime Minister's office unless you've got an exceedingly good brain, you are independent, and you are, in civil service terms, a high flyer. If you're in the Prime Minister's private office, you can expect to rise very high in the civil service over the years to come. Indeed, Jeremy Haywood, from whom you saw notes, became Cabinet Secretary. And you saw in William Chapman a straightforward urge to change policy. Now, had he discussed that with me before he put it all down on paper? Possibly not directly in saying, I want to say this, that, or the other, but he had probably chatted through the policy casually with me and then put down a note reflecting what had happened and his own views of what should happen. So there was a practical case of an independent-minded, high-quality civil servant saying discreetly to the government, you may have got this wrong, it's time to move on. And that is a legitimate role, but it is something that really can only be done by civil servants close to the Prime Minister or the Minister, or very senior civil servants. They can say to ministers, and should, you have got something wrong. There is no one more valuable in your private office than someone who will act as devil's advocate and say, don't do it, it's a mistake.
And I just want to go back to something I asked you a few minutes ago about whether investigating how things had happened and taking steps to prevent them happening again might be a way of avoiding the problem about precedents. And I think the answer you gave in part, at least, was to say, well, that would build in delay. Can I just suggest to you it wouldn't necessarily build in delay, because there's nothing to stop a government doing both at the same time, is there? Making an ex gratia payment to deal with immediate financial need, for example, and doing so quickly, but then taking steps to work out what happened, put in place any appropriate measures to prevent it happening again, and drawing some comfort from that they both avoided the risks of it happening again and potentially prevented other people from becoming victims.
Of course that could happen. I mean, you heard me in answer to one question, and I forget which one it was, but you asked me a hypothetical question. And I said, in those hypothetical circumstances, I would go back and ask for more information. Now, that's an illustration of doing the sort of thing you're referring to. What I was referring to in my answer is you couldn't have a comprehensive investigation like this, because even if it had been set in train in 1995, it would have taken some years, probably, to report, to learn all the lessons. But where you can see more intrinsic or more minor things going wrong, yes, of course, you can do that by a re-examination. And that is relatively routine.
So those are the questions I have. I'm just going to check whether Mr. Murray has anything. No. Do you have any questions for Sir John?
Yes, I do. They all arise out of things which you've said during the course of your oral evidence. And the first was just before lunch. You was talking about settlement. And you spoke of, and your words were, the legitimate claim for help from the haemophiliacs who had been damaged by infected blood. Now, plainly, that was, you're using the words legitimate claim now. Was that the way you saw it at the time?
Well, I think you saw in the evidence I gave this morning that whenever I was approached, I, without dissent, conceded to payments being made to haemophiliacs, with the exception of the last occasion. And I did think they had a good case. Whether I would use the word legitimate or not, I'm not sure. I think they suffered, and it was right for the state to offer assistance to them. I think I would prefer to put it that way.
It brings me really to just two aspects of what you said that were perhaps intriguing. You were asked earlier this morning about something that John Moore said, and you said that John Moore had said at one stage there was not a good case for compensation for reasons of precedent. He did not rule out, nor did he say he'd ruled out, compensation in view of the circumstances of those who were infected. Can I just look with you for a moment at the question of precedent and how it interacts with special circumstances. Precedent, I suppose, involves two things. One may be looking back to the past and seeing if it's been done before or not been done before, so there's a precedent either for doing it or not doing it. It may also be a fear for establishing, by doing it for the first time, as you may think, that it may happen again, and there may be a call for it to happen again, and so you may be establishing a precedent for the future. Those two sides. But in either case, however one views precedent, it only applies, doesn't it, if the facts in each case are sufficiently similar for the principle which underlies them to apply to both cases.
Well, it was the principle that was concerning the government. The principle that unless there had been shown to be a legal requirement to pay because of misbehaviour in some form by the government agency, then there had been no occasion when there had been compensation. And the reference to no-fault compensation was based on the principle that that had never happened before. Governments collectively of all parties, as far back as one could trace, had never agreed in the principle of no-fault compensation. If the government had made a failure, either they agreed compensation or it went to court and they were forced to pay compensation. But to pay compensation without having found to be at fault and without having gone to court had not happened before. And it was that principle, which we loosely called no-fault compensation, that was an inherent part of the instincts of the Treasury in particular, but also across government.
How do special circumstances then affect it? Presumably, it may be that if there are special circumstances, for instance, a landslip at Aberfan, the vaccine damage, things of that sort, which are not simply things that happen. They happen to such an extent and to so many people that they require the state to take some form of action, however one uses the word require. I just mean it in general terms. If you can identify particular circumstances, then it doesn't become no-fault compensation, does it?
No, it doesn't. If you can identify those circumstances, but at the time, there was no scientific knowledge that what was being done in the 70s, which was plainly wrong and caused terrible tragedies, that it was not known to anybody. There was nothing anyone could have done that would have prevented it in the light of what was known by science and medicine at that time. Now, that's not the case in Aberfan. Plainly, they shouldn't have banked up everything that fell down on Aberfan in the 1960s, and so on. So you could find a fault and something that could and should have been prevented. With the lack of knowledge, when someone was doing something for which there was no knowledge that it went wrong, it was done for the best of motives, but it was wrong, then nobody could have foreseen that. Nobody was derelict in their responsibilities. And that really is the point that underlies the no-fault compensation argument.
It may be that you have the same answer to the second exchange, which really caught my ear, and it was in relation to when you looked at a document. I wonder if, Lawrence, you can put it up. HMTR 601_012. It's the letter from Paul Gray, or to number 10, at number 10, of the 20th of November 1989. And it's the second page. And there, if one looks at the point number 1, talking about the discussion which has been held. Now, I appreciate you weren't part of this discussion, but you were asked about this in relation to government decision-making. What Mr. Gray is saying, that the point, as he records it, is in presenting such a package, it will be desirable, and he's talking about the 20 million extra pounds for the
this was to
Farm and
Mrs.
Trust.
Thatcher.
As well as avoiding any acceptance of legal liability, to avoid conceding any moral obligation. So it's payment without legal obligation, it's payment without moral obligation. And you were asked about that, and you said, well, problem with moral obligation is anyone can find a moral obligation for anything, and you've created a precedent. And you, I'll quit your
I think
actual
that's a
words.
pretty
I'm
free
sorry, I'm summarising, and obviously I've got it wrong.
It's a very free interpretation.
Well-
because as was apparent from my later answers, I thought there was a moral obligation. So had Paul Gray
Well-
directed that to me, I might have sent it back and asked him to rephrase it.
It's because otherwise it would seem rather odd, wouldn't it? The government was paying without any obligation, legal or moral, but simply because it, as it were, felt like it, because it was making an ex gratia payment. So,
Well, I think you can make it. I mean, I made it clear I think there was a moral obligation.
thank you.
I made that clear. Plainly, that wasn't the view of Mr. Gray when he wrote that particular minute, and then maybe that wasn't the broad opinion at that time in government. I think there was. But I think at the time of that government, they would still have made a payment, because it is almost impossible, unless you are completely compassion-free, not to understand the sheer horror of what happened, not only to the people who were infected with the blood, but their families. And the wider implication that would have had on a lot of people's lives. I don't think any government would have stood wholly away from that. What they would have done would have tried to avoid a precedent that could be misused. And the risk always with this is the misuse of precedent. And I'm sure, like me, you can see all sorts of ways in which this might, a completely free acknowledgement of moral obligation would open all sorts of things. Did the government have a moral obligation because they didn't know about something and they didn't do it? Well, you could argue they do in every respect if you start conceding moral obligations here. Now, I think the times have changed and we can do that. And I think the experience that we've had since 1989 with the introduction of ex gratia payments gives us a way round that moral maze. But I can see that Paul Gray was a very able civil servant, I may say, in the Prime Minister's private office at the time, and previously, from what I recall, Paul Gray was a senior official in the Treasury. So I can quite see why he would have phrased it that way in the light of thinking in the 1980s, but I do not myself personally agree with it.
Now, you've said in that answer that you yourself regarded there as being a moral obligation. You said earlier that you thought that the ex gratia principle was a way forward, if you like, for the future. How did the two interact?
Well, I think if you can make an exceptional case, and plainly in this case you can, if you cite a legal obligation, that's a very unwise thing to do, because how can you determine it? The courts may consider differently. Indeed, the advice the government got repeatedly, right through the compensation packages we produced, was that if we went to court, if we were taken to court, the balance of probabilities is that the government would win the case. And that was repeatedly the advice. That being so, you are using public money without a legal justification. So if you cannot have a legal justification, what is your justification for spending the taxpayers' money? And there has to be one. I would call it a moral obligation. Other people may call it something different. But I think we have to recognize that those circumstances will occur. And in a civilized society, the majority have an obligation to a minority if that minority falls on particularly hard times. The same principle applies, of course, with social security payments. There's no legal obligation to pay a social security payment to someone who is unemployed, but there is an obligation in a civilized society to do so. And you can equate that as a first cousin, perhaps I might say, to what has happened with the ex gratia payments in this particular case.
Thank you very much. That's all that I ask.
Sir John, is there anything that you wish to add?
I think I'm done. No, I don't think so, thank you.
Sir Brian.
Well, I just want to express our gratitude to you, Sir John, for coming and giving your evidence to us. the measured evidence, as it's been described already online, your willingness to consider the material which you've been sent, and indeed to reflect and perhaps change your mind to the extent that you consider that you may have got a decision wrong in respect of hepatitis C. And for that, I think you deserve the respect of those who've been listening. You've given a clear explanation of your role at the Treasury and at Prime Minister, as Prime Minister, and that's been helpful. And how, despite being like a supertanker before it turns, government is often unseen but on the move. And that's valuable to hear from someone who's occupied the highest positions of state, such as yourself. Thank you very much.
Thank you very much. May I just say one thing? I obviously caused offence inadvertently this morning when I referred to the fact that it was awful that people had been fed infected blood, and I referred to it as sheer bad luck. I can only say to people it wasn't intended to be offensive. I was seeking to express the fact that I was concerned about what happened, and what I meant was the point I raised earlier, that by sheer bad luck, it was a random sample. There were 65 million people in the country in the 1970s, and 3,000 people had the appalling outcome of having been fed infected blood. So I just wanted to say, if anybody thought I was being dismissive or offensive, please don't think that. That certainly was not my intention. And I was rather surprised. Well, perhaps I'm not surprised at the sensitivity. I think if I were in the position of those people who either had infected blood or whose families, someone in whose families, I would be sensitive as well. So I would just wish to say to you that if that caused offence, I apologise. It wasn't intended to do so. It was intended simply to say that it was a random matter, and I perhaps expressed it injudiciously. And if I did, I apologise to those who were offended.
I think it was an unfortunate choice of words.
Yes.
But I think it may have
was.
been unfortunate, partly because bad luck looks as though you're talking about cause.
Yes, I know.
And
I know.
random event is
Yeah.
looking at incidents, and they're two different things.
I must have answered 500 questions today. I'm sorry I got one. I responded to it in an inelegant way. I'm sure we will read about it tomorrow.
And so moving to tomorrow, we have the evidence of Virginia Bottomley, Baroness
Yes.
Bottomley.
Thank you very much.
Fine. Thank you very much indeed.
10 o'clock tomorrow, Virginia Bottomley.
Thank you.